right, this is case number 24 CR 050, State of Ohio versus Bailey Morgan Simmons. And you're Bailey Morgan Simmons?
Yes, sir.
All right. Mr. Simmons, you were indicted by the grand jury on March the 5th on a charge of failure to comply with the order or signal of a police officer. That alleges that on or about February 20, 2024 in this county, you operated a motor vehicle so as willfully to elude or flee a police officer after you received a visible or audible signal to bring your vehicle to a stop, and your failure to do that caused a substantial risk of serious physical harm to persons or property. That's a third-degree felony which carries a possible prison term of between 9 and 36 months and a fine of $10,000 and a mandatory license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you in this matter. If you do not have the funds to hire one, the court will appoint one for you, and I see you have filled out a form here. Now, you put down NA on everything. That means not applicable. It's applicable because you're supposed to disclose your income and expenses. Do you have any income?
No.
Pardon me?
No, sir.
All right, so that would be 0. That's what you should have put on the form, not applicable.
Okay.
And why aren't you working?
I've been trying to get a job. I filled out applications. There's a few places I got denied.
When was the last time you were employed?
It's been several months, probably about 6 months.
All right. So you're living with your grandparents and they're paying all of your expenses?
Yes.
Okay.
I've sold some of my personal belongings to try to help out and give some money for groceries and things and help take care of my daughter, but as much as I can do.
All right. Well, I see you're 24 years old. Doesn't seem to be any reason why you should be working. But if your grandparents want to let you live off of them, I guess that's their business. For the purposes of the law, I'll find that you are entitled to appointed counsel. Have you been in court on this case before today?
I'm not sure.
Pardon me?
What was
Have
it?
you been in court on this charge before? Were you arrested and appeared in another court before you appeared here today?
Not for
on this
the
charge?
same charge, I don't think, other than Greenfield.
Okay, you were arrested in Greenfield?
Yeah.
On this charge?
Yeah, for this same charge. That.
Okay, well, did you have an attorney over there?
Yeah, and then they bound me over to here.
Okay, who was the active attorney?
Armentrout. William.
All right. I'll appoint Mr. Armentrout then to represent you in this matter, and I'll enter a not guilty plea on your behalf. All right. Well, Mr. King, there's a report from your office on the Raymond sheet says that this case was bound over, but I don't have this as a bind over. This is showing me to be a direct indictment. The reason I'm asking because it says he posted bond. We don't have anything in this file that shows that it was in Greenfield.
I'll have to go check it. I don't have this file with me this morning.
Okay.
I can't give you an immediate answer.
What was your bond in the county court? Remember?
I think it was 100,000 before they awarded me.
Okay, now this says 10,000. Did you post that bond or did it give you an OR?
They give me an OR.
OR only? You didn't have to put up a bondsman or anything like that?
No,
All
sir.
right. All right. Well, I'm going to release you then on your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony and if convicted, sentenced on that, no matter what happens in this case. You'll also be you're required to pay a $171 deposit for certain statutorily required fees within 30 days. You make payment arrangements at the clerk's office. And you'll be under pretrial supervision. The probation department, 117 East Main Street. It's just down the street on the opposite side of the street from here. You report to them as soon as you get done with court and after you signed your OR bond at the clerk's office. You're going to be required to report to them once a week for 4 weeks, and after that, as they determine, under the random drug testing they may order. Provide phone numbers for home, cell, employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. Any treatments indicated, you're to enroll in and follow that during the pendency of this action. You're going to be under house arrest at your residence at 601 Edgewood Avenue in Greenfield, which means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of educational programming, job training, college classes, etc. You can also go to church services. And then working also means looking for work, but you'll have to notify the probation department when and where you'll be going, and you have to go directly there and back. You may not do any side trips or anything of that nature. If you fail to comply with these conditions, then the court could revoke your bond and order you to be held until further order of the court. Now, we're going to set your first pretrial on this case for April the 3rd at 2:30. And if you have an email and either a computer or an iPad or a phone that you can do video conferencing on, give that information to the bailiff, and if it's possible we can do those by Zoom rather than you having to come over here for the hearing. Your final pretrial will be May the 1st, also at 2:30. And your trial will be set for May the 23rd at 8 a.m. All right, now when you were arrested, were you fingerprinted and photographed at the Sheriff's Department?
Yes, sir.
Not at Greenfield, at the Sheriff's Department?
Yes, sir.
All right. So you're going to then get an assignment notice here from the bailiff, gives you your dates and times for your court hearings. You're going to go downstairs to the clerk's office to sign your OR bond and make payment arrangements on your deposit, and then you're to go to the probation department. You have any questions?
Yes. If I get like an interview or whatever, I just check in with my officer, like you said.
Yep.
Okay.
Yep, or if you're going to go put in applications or anything like that, you just let them know in advance.
All right.
All right, thank you. Norman Benson Sr. Case number 24 is CR 42, State of Ohio versus Norman Benson Sr. Are you Norman Benson Sr.?
Yes, sir.
All right, Mr. Benson, you were indicted by the grand jury on March the 5th on a charge of possession of heroin that alleges that on or about January 27 of this year in this county, you knowingly obtained, possessed, or used heroin. So that's a 5th-degree felony, which carries a possible prison term, if convicted, of between 6 and 12 months, and a fine of $2,500, and a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney represent you, and I said you filled out a financial disclosure form, and you showed nothing in terms of income. Why aren't you working?
I'm fighting for my disability. I've had 15 surgeries, going on my 16th and 17th.
Okay. All right, well, it looks like Mr. Armentrout represented you at the county court, is that correct?
Actually, I didn't have no lawyer there.
Right.
they didn't give me no paper. I kept asking for the paper, and he
Yeah.
represented me last time. I mean,
Well, according to this, he was your attorney, so I'm gonna go ahead and appoint him to represent you
that's fine.
in this case and enter a not guilty plea on your behalf. Your bond is an OR only, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case, you'll be required to pay a deposit of $171 for statutorily required fees. You'll be under pretrial supervision of probation department at 117 East Main Street in Hillsborough. You know where that's located?
Yes, sir.
You report there as soon as you get done here and go downstairs and sign your OR bond. You're going to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you'll enroll in and follow that during the period of this, during the pendency of this action. You'll also be under house arrest at your residence at 4123 Bell Hollow Road, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of schooling, job training, educational programming, etc., and church services. Other than that, you have to be there at all times. If you fail to comply, the court could revoke that bond and have you held until further order of the court. We're going to set your first pre-trial for May the 1st at 2:00 p.m. Your final pretrial will be June the 5th at 2:00 p.m. Your trial date will be June the 24th at 8 a.m. All right, and have you been fingerprinted and photographed and booked at the sheriff's department on this
Yes.
matter? All right, then you're going to step around here and get your assignment notice with your dates and times for your hearings. You're going to go downstairs and sign your OR bond, make a payment arrangement for the deposit, and then go to the probation department.
Okay.
All right, thank you. Around that way. All right. We don't have a return to service on Mr. Hawkins. That's why he's not here. Unless you got something else that's not in the flip here. Oh, wait a minute. Nope, we do have it. All right. Case number 24 versus Anthony W. Hawkins. Present for the state's Assistant Prosecuting Attorney King. And Mr. King, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, the alleged victim is present in the courtroom today.
All right. Mr. Hawkins is not present. The record will reflect that he was served with this indictment according to the return from the sheriff by Deputy Sederet on March the 20th. The arraignment was set at 8:30. It is now 8:52, and he is not present. So the court will order a capias to issue for his arrest, and when he is brought before the court, then the court will notify the prosecutor's office to reset the arraignment. Thank you. All right, this is case number 24, CR7. Oh, wait a minute, we don't have a, oh yeah, we do. 24 CR17, Stable High versus Brandon Williams Sr. Are you Brandon Williams Sr. appearing there from the jail?
Yes, sir, Your Honor.
All right, Mr. Williams is charged with theft, a fifth-degree felony. This is an arraignment. He was indicted by the grand jury on February the 6th, 2024. Mr. King, on behalf of the state, as the alleged victim of the offense, been notified of the time, place, and purpose of this hearing, the right to be heard.
Yes, they have, Your Honor, and they've elected not to attend the hearing this morning.
All right. Mr. Williams, you're charged with theft, which alleges on or about December 29th of last year in this county, you did with purpose to deprive the owner, identified as V, of their property, knowingly obtain or exert control over it, to wit 30 rolls of copper wire and other miscellaneous items without their consent or person authorized to give consent, and the value of the property is over $1,000 but less than $7,500. That is a charge of theft, a fifth-degree felony, which carries, if convicted, a possible term of incarceration of 6 to 12 months and a fine of $2,500. Now, you are entitled to have an attorney to represent you in this matter, and if you don't have the money to hire one, the court will appoint one for you. I see you have filled out a financial financial disclosure form. Is everything on this form correct?
Yes, sir, Your Honor.
All right. Is this the first time you've been in court on this hearing, on this case?
Yes, sir, Your Honor.
All right. The court will appoint Attorney Dennis Kirk then to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf.
Yes. Your Honor.
Hold on.
Yes, sir.
All right. Bail review hearing will be set in front of the magistrate on Friday, March the 29th at 9 a.m. The first pretrial in this case will be set for April the 3rd at 1:00 p.m. Final pretrial will be May the 1st at 1 p.m. Trial date will be set for May the 20th at 8 a.m. All right, now, Mr. King, anything on the matter of bond you'd like to address?
Only was contained in the bond recommendation sheet, Your Honor.
How much was that?
$2,500.
Okay, now, according to your financial disclosure form, Mr. Williams, you're living in Cincinnati?
Yes, sir.
I had in my notes that you were in the Montgomery County Jail. Are you being held up there for something, or did they release you?
Yes, sir, that's what I wanted to talk to you about. I have both my sentencing paperwork from Warren County, Ross County, and Montgomery. I've been sentenced to go to a CBCF, CCC, and I have a bed waiting on me. All this is stemming, well, not talking about the case. The stuff that I've been basically sentenced for stems around basically a drug problem. They have sentenced me to CBCF, CCC.
Have you been sentenced on those cases?
Yes, sir.
And are you being held on those cases in those counties?
Yes, sir, because it's been
Okay.
off the hold for me to make sure that I get this program
Okay. Well, let me say this, I was asking about that because of bond, but generally speaking, most of the CBCFs will not take somebody if they've got a pending case, because they gotta be brought back and taken out and brought in and so forth, and it disrupts the programming. So, do you have a definite bed date yet?
Yes, sir, they have, they've been waiting on me to.
What date is the bed date?
The day that I got sentenced in Montgomery County, which was, hold on, I had that date here, let me look through my paperwork, sir.
Okay, what is the do they have a definite date for you to be there?
Yes, sir, it's already been, I'm supposed to have been there.
All right, and then what CBCF are you talking about?
It's CCC in Lebanon, Ohio, I believe that's.
Yeah, right, that's it, yeah, all right.
Community Correction Center, and I've been scheduled to go there since 2/20. This was the last place. I know that they said that if I do with the last court, I can either do the Zoom court from there, or that they will transport me to court. This is the last court that I have. So
All right, well, here's what I'm gonna do. I'm not in a position to, I mean, we're gonna have to have confirmation of all that. And if they're willing to take you and keep you there during the pendency of this case, then I will agree to that. Right now, I'm gonna order a $2,500 bond. You're gonna need to talk with your attorney. We'll notify him of his appointment today, and he can hopefully get in touch with you, get that paperwork, and then contact the CBCF and the court. Well, gonna have to confirm with the probation departments that they're willing for this to happen, that they will take you with this case pending. Different ones are different, so, you know, I think we can probably work that out. But for right now, I'm gonna go ahead and order the standard bond of $2,500 and the standard conditions, and then we'll get a hold of your attorney, and hopefully he can get out to see you today or tomorrow and talk to you about it and try to see what can be worked out. And if that's the case, if they agree that you'll be held there, then I can lift the bond, and I agree for you to be put there with a holder. And we do Zoom hearings from CBCFs all the time, so you know, we can work that out. So,
yes, sir.
but again, we'll have to wait and see what's going to happen. So I'll give my assistant this, and she'll know to get a hold of your attorney right away. All right?
Thank you.
All right.
God bless.
Okay, this is case number 15 CR 0168, State of Ohio versus Edward Conant Jr. And are you Edward Conant Jr. appearing there on the screen that's marked Jill Ez?
Yes, sir.
All right. This is a hearing on the status of Mr. Conant, who's been placed in the facility, Southwest Ohio Development Center, after a finding of incompetency to stand trial. His attorney is Dennis Kirk. This hearing is being conducted by Zoom. And I believe that was at the request of the defendant. Is that correct? Mr. Kirk?
Yes, Your Honor.
All right, and you're in agreement with that?
Yes, Your Honor.
All right. The state's represented by Assistant Prosecutor King. The defendant was indicted back in July of 2015 on 2 counts of rape and 2 counts of gross sexual imposition, with the alleged victims being under 13 years of age. I guess it's the same alleged victim. Mr. King, was the alleged victim or a representative of the alleged victim notified of the time, place, and purpose of this hearing?
We've attempted to, Your Honor, with this case being several years old, we did not have a working phone number anymore. Also sent a Facebook message to attempt to make notification that way, but have not been successful.
All right. Court then will find that the state has made sufficient efforts to comply with Marcy's law and the recent statutory supplements to that for purposes of this hearing. All right. The court has reviewed the report that was dated February 29th and was 2024, was filed with the court on March the 7th. Have each of the attorneys received a copy of that report?
The state has, Your Honor.
I have, Your Honor.
And do either of you wish to offer any additional treatment or wish to examine those individuals in the reports?
The state does not, Your Honor.
I do not, Your Honor.
All right. Well, then, based on the report from Dr. Bossman, chief psychologist, and the Daniel Bossman, or I don't know, is it Bossman or Bashman? Bashman. Okay, coordinator psychological services. It is a recommendation of the SODC treatment team that he continue to undergo treatment, and that he is subject to institutionalization under the statute. There's no available placement that would be less restrictive, that would protect the general community as well as the safety of the defendant. And so the court will go ahead and order that the placement be continued, and that SODC continue to report to the court on periodically as required by law. All right. So, Mr. Conant, you'll be staying there with the folks there southwest, okay?
Yes.
All right. Thank you. All right, good morning. This is case number 22 CV 212, Philip J. Wyrick et al. Versus Brandon Farms LLC. This is a hearing on a motion to quash a subpoena filed on behalf of the Highland County prosecutor and assistant prosecutor. The plaintiff is represented by Kevin Bowman. This hearing is being conducted by Zoom based on the short notice and the need to try to address this matter as quickly as possible. The plaintiff is represented by Jess Weed, defendants represented by Kevin Bowman, and the movements are represented by Lynette Dinkler and John Benintendi. They are all present. All right. The motion seeks to quash subpoena to take depositions of Prosecutor Collins and Assistant Prosecutor Bowling. Now, I've reviewed the motion and all the supporting documents, and so I'm going to, instead of asking for movement to make any statement, I'm going to ask the defendant to respond to some questions that I have. First of all, Mr. Mr. Bowman, on behalf of plaintiff, I'm trying to figure out how the depositions of these two officials are not covered by the attorney-client privilege, because it seems to me that the gist of your claim is that the defendants solicited their daughter to solicit the prosecutor to advise the commissioners not to do something, and so that would seem to me to be the very essence of attorney-client privilege. So can you address that?
Let me mention that I do have Doug Brandon who moved out of the country and currently in Pleas available by cell phone, so he is listening in and available to participate. He doesn't request that Brandon Farms representative participate, so Doug is actually here with me on this. So, Your Honor, we have these emails that we received during the course of discussion between Carlisle Wyrick and Annika Collins. We don't think that we're covered by the attorney-client privilege. One, we have them already.
Well, what are those specific communications? Because I have no idea. I do see that there was one that you said was sent to Ms. Wyrick from the prosecutor, I believe dated December 30th of 2022. And I have not seen that, so I don't know what it is, but are there others?
Yes, there's a bunch of correspondence going back.
Can you identify those for the record? I'm having a little trouble hearing you. Maybe there's a little reverberation. Maybe you could speak up, get closer to your microphone.
Yes. Is that better?
I don't know, is everyone else having the same trouble I'm having? Yeah.
Yes.
I have not had a lot of problems with this.
Let me suggest this. Why don't you log out and log back in? And we'll just put a pause on the recording and go off the record while you do that.
Okay, I will do that.
Okay, I have you back, Mr. Bowman.
Is there any improvement?
There's better volume. We still have a little muffling of some sort, but your volume is better. All right, so go ahead and give me the dates of these communications that you're referring to and who they're to and who they're from. Or to whom they're directed?
A bunch of emails back and forth between Annika Collins and Carletta Wyrick dating back from July 21st, 2021, July 22nd, 2021, August 23rd, 2021, August 24th, 2021, multiple ones on that date, August 25th, multiple ones on that date, August 26th, multiple ones on that date, August 30th, multiple ones on that date, then September 7th, September 13th, multiple ones on that date, December 26th, December 28th, December 28th, and December 31st.
All right.
And February 9th.
And are these directed to Ms. Wyrick as a fiscal clerk for Jackson Township, or to her personal email?
They're all relating to the Brandon Farm, which is,
Well, my question was about the emails that you ran off there, and again, I had some trouble understanding them all, but I know there were quite a few in 21 and 22. And my question is, are they between Mrs. Collins and Ms. Wyrick as a township official, or are they in a personal matter? What is the address, the email address that Ms. Wyrick was sending and receiving?
the Jackson Township email.
It was on Jackson Township email account?
Yes.
Okay. And so then, and again, I don't have the benefit of these, but so the gist of it was, as a fiscal officer of Jackson Township, she emailed Ms. Collins, and Ms. Collins responded to her?
That is correct.
All right. How did you come into possession of these emails?
Unfortunately, discovery of this letter.
All right. Mr. Weed, on behalf of the plaintiff, you came into these from your client?
That is correct, Your Honor.
Well, she's a private citizen in this case, so why would her emails as a township official be something that should have been disclosed to you, let alone to someone else?
In my opinion, disclosed to me, and of course, once I have them, then I think I had to disclose to Brandon Farms. So she disclosed them to me in an effort to show that there was in fact no collusion, no wrongdoing whatsoever on behalf of her as the fiscal officer. So she provided those to me through the course of this discovery upon a discovery request back and forth with Mr. Bowman and Doug Brandon after the deposition. Carlita gave those emails to me, and then I felt that at that point in time I didn't have a choice but to disclose them.
Well, I think that as an officer of the court and an attorney, that if you come into possession of something that appears to be confidential rather than publish it, you should have contacted the prosecutor's office to discuss that. That's certainly is because, and again, I guess the other question then I have for you, Mr. Bowman, is, I've looked at all of I reread your amended complaint, and, it's hard for me to understand how a fiscal officer has any impact upon this issue anyway. The township trustees are the ones who the commissioners look to see what their position is, and they, apparently, I would assume she would express her concerns, her and Mr. Wyrick expressed their concerns to the trustees. My understanding from the pleadings is the trustees said we're okay with it, and it went to the commissioners, and then the commissioners did not go forward with it. And so I fail to see how that constitutes action on behalf of, in her position, because her position as fiscal officer is irrelevant to the proceedings in front of the commissioners.
You're absolutely right. It is relevant.
Pardon me?
You're right. It is.
If I'm right, then you should dismiss the case because they are irrelevant. They don't have anything to do with it.
What happened was that she directly solicited information from Ms. Collins in her capacity as the township fiscal officer, and and declined to act on the form because Ms. Collins told her to, and she told them to because Ms. Wyrick said, I have all these problems regarding the issues between Lee and Granite Farms LLC and the location of the road. And we think that was one violation of Ms. Wyrick's duties under Ohio law. And there appears to be a direct causal link between Ms. Collins telling when commissioners don't act and they're not acting.
Well, I was a prosecutor for 24 years, and I always took the position, and as did the commissioners, that if there were any title disputes or if the vacation of a public right-of-way may affect a right-of-way, that they would not take any action on it until that dispute was resolved, and then once that was resolved, they could act. You've now had the court has resolved that issue. You certainly could go back and ask them, but again, Miss Wyrick, I will say this: I think she was wrong in terms of at least morally. I don't know if it's right. I'm not going to make a comment on the legal issue, although I think that there's some on the face of the pleadings, there certainly seems to be some problems with that as well. Is the fact that she's just somebody that as a fiscal officer, I assume Miss Collins was responding to her, which in hindsight she probably shouldn't have, because Miss Wyrick doesn't have anything to do with it. And if it did involve her, that probably should have just said, I'll deal with the trustees, because the township is the client, and the trustees make up the board of trustees of the governing body. And her position as fiscal officer is really an administrative position. She has no legislative or policy-making authority. And when she says, "I believe such and such," you know what? So does if I have an opinion, it's worth about that much as a private citizen. And so again, I see a real problem with this. And so if she, and again, I don't know if I haven't seen these. Did Miss Wyrick disclose to Miss Collins that the property involved was hers?
In earlier emails, but not later, and it's quite possible that Ms. Collins was unaware of the later emails that we were talking about at the same time.
All right.
Early, certainly.
Okay. All right. Now, Ms. Dinkler or Mr. Benintendi, I'll let either of you weigh in on this, on the issue. I'm focusing first of all on those emails, but my question was whether or not that might be something that, if she was communicating with Ms. Wyrick as an individual citizen, that would not be covered by privilege. So I'll hear from you on that. Again, keep in mind, I don't have the benefit of the emails. I haven't seen them.
Thank you, Your Honor. May it please the court, my name is Lynette Dinkler. I represent the prosecuting attorneys in this matter. With regard to the email that the court has inquired, I am aware of no email that was sent in a personal capacity from prosecuting attorney Anika Collins to the fiscal officer, to the township, or to the county. All of them that I have had the benefit of reviewing have all been in official capacity and have all fit squarely in the confines of the attorney-client privilege. I've provided all of those emails to the expert engaged for outside consulting review, and Mr. Matthews arrived at the same opinion that they are all classic attorney-client privilege emails with an official capacity only. And I don't want to be, the court is familiar with the issues given the court's background. There is no waiver here. And there was no communication at the time of disclosure that I am aware of to the prosecuting attorney's office or the prosecuting attorney to have intervened at the time of the disclosure.
All right. Mr. Weed, do you want to weigh in on this?
As to whether the emails contain, whether they are confidential and protected by the attorney-client privilege, I will weigh in to the extent that I do believe that all of the emails were sent from account that Ms. Wyrick uses as a fiscal officer, not as a private citizen. And I also believe, and I would echo with what Mr. Bowman said to an extent. She did disclose in the early iterations of the emails that she was personally involved with this property. As time went on, the disclosure, she didn't say that in every email, although from our position, it's something that had already been relayed to Prosecutor Collins, and since it had already been relayed, it didn't need to keep being relayed each and every time. But that's, I don't know if the court has any other questions, I'm happy to answer.
Mr. Bowman, anything else you would like to say?
Well, certainly, Your Honor, we don't agree with Ms. Dinkler regarding whether these were emails, but simply because they came from her official email account does not mean that they had to do with the business of the trustee. They clearly had to do with her personal business, which is the Brandon Farms. And I should also mention that there is a crime fraud exception to the attorney-client privilege, which is also applicable in this instance because it is, in fact, a crime to misuse one's position, as we believe Ms. Wyrick did, in allowing her contacts with Ms. Collins to drive the legal outcome of this case.
All right.
And the crime, of course, is not the same cited in our amended counterclaim.
Well,
Your Honor, may I?
okay, go ahead.
John Benintendi, I represent Molly Bullock, Assistant.
Oh, I'm sorry, I forgot there were, yeah, okay, go ahead.
That's quite all
Yeah.
right. The first thing I'd like to say is all the emails that Mr. Bowman points out were from Prosecutor Collins to Ms. Wyrick to her Jackson Township emails we've discussed. Not one email is from Molly Bullock. There's not one. And so in terms of the information that may apply to Mrs. Bullock as assistant prosecutor, there's been no disclosure because there aren't any. So when it comes to the assistant prosecutor, there is no evidence whatsoever that she had any communication with either the township or the county commissioners. And in fact, her affidavit clearly spells out she doesn't communicate, especially with Jackson Township, given that her mother's fiscal officer. There is a wall in the prosecutor's office where she just won't do that and hasn't done that. And Mr. Bowman clearly hasn't provided any evidence that she did. Ms. Wyrick testified, and Mr. Wyrick testified that they didn't talk to her about this. Some ancillary issues, maybe an attorney here or there, but Molly's been very adamant with her parents. They do not discuss these type of issues, given Ms. Wyrick's position and Molly's position within the prosecutor's office. So, in other words, there's no basis whatsoever for the allegations, and therefore no basis for the deposition of Molly. And as to the attorney-client privilege, Ms. Wyrick can't waive that for the township. They would have to do that, and that has not been done. So that's all I'm going to say on that point, because all the emails were from Ms. Collins as prosecuting attorney and not Molly Bullock.
All right, Mr. Bowman, since I had overlooked the fact that Mr. Benintendi was separate for Ms. Bullock, I'll give you an opportunity to respond to what he just said as well.
Sure, Your Honor, it is true that we have no evidence regarding any communications with Ms. Bullock regarding this matter. And as a consequence, there can be no assertion of attorney-client privilege. So there's no evidence that there were attorney-client privilege discussions between Molly Bullock and her parents regarding
Did you depose the Wyrick's other children?
I didn't,
You did not?
I don't even know if they have another children.
Okay.
The purpose, I mean, in our mind, and I think it's perfectly reasonable, what we saw was that Ms. Wyrick got the prosecutor's office to issue the instructions to the commissioner, don't vote on this. Under the Ohio, and Ms. Ball works for the prosecutor's office, she's the daughter of the Wyricks. It seemed like a reasonable subject for inquiry.
Well, the depositions of both Philip and Carlita Wyrick both indicated that when they asked Ms. Bollick, she definitely said she was not going to speak with them about it. The only thing she would do is give them the name of an attorney, which she did, which is not the attorney they hired. And she has signed an affidavit under oath saying she has no knowledge of it and that there's a wall. So I don't see any reason for you to take her deposition. If you want to get her under oath to say, that I know nothing, you have her under oath already in that affidavit. And your argument's further undermined by the fact that you didn't ask for the same thing from their other children, or I don't know how many other children they have. I know they have at least one, a son, so I recall from reading the deposition. So based upon that, I see no basis for Ms. Bollick to be deposed, and so I'm going to quash that subpoena. In terms of the other issue, it seems to me it's clear that what you're after is attorney-client privilege. You have, and I'm going to say this, Ms. Wyrick apparently doesn't have any appreciation for the appearance of impropriety that she creates when she is involved in a matter that's before the township trustees and the county commissioners, between her position as an individual and as a fiscal officer. Fiscal officer is an administrative, ministerial officer. They do not make decisions for the trustees. Now, I do know from my experience as 24 years as prosecutor and another 8 as an assistant in Adams County advising civil clients that often the trustees do request the fiscal officer to send information and be the conduit, but there's no indication of that here. Certainly she was using the township email account on a matter that was concerned her personally, certainly isn't appropriate. I think it's relatively minor in the overall scheme of wrongdoing, but it is unfortunate, and Ms. Wyrick's conduct has put her daughter and the prosecutor's office an unnecessary position here. And it's unfortunate that the prosecutor didn't find out more definitively about the involvement of Ms. Wyrick, and upon learning that, I would assume that she would have said, look, you have a conflict of interest here, you can't be the person doing this on behalf of the township because you're involved. And she wasn't, because the trustees didn't pay any attention to her and her husband. I mean, not that they didn't pay attention, but they didn't adopt their position. The process that worked at least for the last 35 years that I'm aware of is that most of the requests to vacate alleys and streets are by a written request to the commissioners, and then they ask the trustees to weigh in on it, or they tell the person before you request it, get the trustees' approval, which apparently was done here according to the pleadings. And then the commissioners will, sometimes if there's a petition filed with a requisite number of signatures, I believe normally they do give out notice to adjoining owners and ask for their opinions. In this case, there's only 2 owners involved, both of which are parties in this case. They can conduct a hearing on it, or they can conduct no hearing on it. And apparently, from what I see, there wasn't a hearing conducted. Is that correct? All right. And again, I suspect it was because of this issue, which again, I understand completely, because had they gone ahead and vacated it, then, and if ultimately the court had ruled that there was a right-of-way from their property over to that part that was vacated, then that would affect a substantial right that would potentially put the commissioners in a vulnerable position. And so that makes perfect public policy sense to avoid that. I know we often would get petitions, people, I want to vacate this because it's on my land, and we'd make it clear to them, the commissioners vacating a public right-of-way does not vest title in anybody. It is according to where the road was located. And as I indicated in my decision in this case, I think that the Wyrick's contention that the road was not constructed in the right place appears to be pretty clear to me, based upon the legal description. But it's been that way for 100 years. And, to ask me to declare that it's in the wrong place, there's a procedure for that, which is what I pointed out. I had to raise that issue. Nobody else had raised it, including the defendant, that, when the court has no jurisdiction, the court sua sponte must raise that if the court's aware of it, which I was. And again, as I pointed out in our discussion last week, that even if the road were constructed in the right place, it wouldn't make any difference because it wouldn't give them an access across to where the road is actually now. So that would not have helped them at all. It would have been an exercise in futility. And whether or not they could have the commissioners could have gone ahead and vacated the road then anyway, because it's not there. It's never been constructed. But anyway, looking at this, the court is going to quash the subpoena for Prosecutor Collins as well. That clearly is attorney-client privilege that the plaintiff or the defendant should not have had. Wyrick should not have given that information without consent of the trustees to Mr. Weed. Mr. Weed should not have given it to you. And I want all of those documents either sealed and submitted to the court. I want all copies to be either destroyed or sealed and filed with the court if you want to preserve that for purposes of an appeal. I'm also going to say that I don't think it's necessary because, again, the commissioners make the decision. And, all of you are lawyers and you all know that, clients don't always listen. And so the commissioners had the final say. But again, just as an aside, as I said, that's been the policy of in the county for years since I was prosecutor, starting in '77. And to my knowledge, it's never changed, and that is when there's a dispute among property lines, whatever, the commissioners don't get involved in that. That has to be resolved between the parties, and then they can take a look at it. Now, one of the things, so anyway, I'm going to quash that. So, now, with that said, and I believe Mr. Benintendi, Ms. Dinkler, unless you have anything further, I'm going to also order the defendant pay the cost of this proceeding regarding that. If there's anything else you want to bring up, you may. Otherwise, you can sign off because I'm going to go off the record and have a conversation with the remaining persons.
Go ahead, Ed, I'm sorry.
That's no problem, John. Your Honor, I just wanted to thank you for your time this morning and for hosting us by Zoom. I personally appreciate it very much.
You're welcome. Thank you.
Your Honor, the only other issue I can think of is that, on behalf of Assistant Prosecutor Bullock, and if I may, Prosecutor Collins, as we put in the proposed order, is to strike the allegations in the original counterclaim, as well as the amended counterclaim, from the record, given the nature of the allegations that can be used against these two public servants.
Well, I have no problem in doing that in the original one. I'm going to go ahead and order that stricken because those have been amended, and I thought at the time when I looked at it, I'm thinking that that seemed to be pretty amazing that something like that would be alleged. And it was taken out in the original. Now, in the amended complaint at this point, those claims are still before the court. I'm a little puzzled that there wasn't a summary judgment motion filed on those, but there wasn't, so right now those are still before the court. So I don't believe I can strike that until there's a disposition. If there's a disposition that's unfavorable, then I can consider it at that time.
Your Honor, I believe what Mr. Benintendi was referencing wasn't allegations of wrongdoing against the prosecutors, but allegations disclosing the attorney-client privilege, which are itemized in the proposed.
Oh, okay, yeah, then I will order any, and if you want to send me an order with that specific provision in it, then I will approve that and sign it.
Yeah,
The court has it in the proposed order.
right,
Okay.
and what I was alluding to the conspiracy allegations in the original counterclaim.
Right.
String.
Yeah, that will be stricken.
And then the attorney-client relationship, yes, and the disclosure.
All right.
That's what that pointed out.
All right. Anything else, Mr. Benintendi or Ms. Dinkler?
I have nothing.
All right,
else.
okay, if you would go ahead and then sign off, and I'm going to go off the record then.
Very good.
Thank you.